Hello and welcome to the Roundup. Inside this month, we're going to give you what you need on the key issues for accountants and advisors, including the final position on the contractor versus employee distinction, that old bugbear. We'll also look at superannuation and the December CPI increase and its impact that it's going to have. We'll also look at what you need to be telling your clients about the impending crackdown on the sharing economy. But first up, we're going to go across to Michael Carruthers on Section 100A. Michael, there's been some developments on Section 100A. What can you take us through?
Yeah, just before Christmas, the ATO released two final documents relating to Section 100A that had previously been released earlier in the year in draft form. So the ATO has released a final tax ruling on Section 100A, which basically explains from a technical point of view how Section 100A operates and explains some of the key exceptions to those rules. Now, many of you would be aware that Section 100A is really an integrity rule around the taxation of trust income. And basically it can apply when income that's been appointed to a beneficiary and the real benefit of those funds is provided to someone else in connection with a reimbursement agreement, some sort of agreement that's in place at or before the time the income was appointed. But there are some exceptions to that, and one of the big ones is this integrity rule should not apply to ordinary family or commercial dealings. And the ATO spent some time looking at what does it mean for something to be an ordinary family or commercial dealing. The PCG that was released in final form kind of expands in a sense on what's in the ruling, but moves into, I guess, more practical territory. So within the PCG, we see a lot of examples of things that the ATO considers to be lower risk and things that the ATO considers to be higher risk. Now, many practitioners would have been familiar with some of the scenarios that were in the draft version of that PCG. Well, we now have the final version of that, and you'll notice that some of the scenarios have been tweaked a little bit. And some of the examples have been changed too. There are some new examples as well, which particularly for some of us might just provide a little bit of comfort. For example, the ATO suggests that Section 100A is unlikely to apply in situations where the beneficiary who's been appointed the income receives the real benefit of that within a 2-year period. And that wasn't a feature of the original draft PCG. That's something that we're seeing in the final version. Now, again, for those of you who have clients involved with trusts, this will be something you need to get your head around as we get particularly towards the end of the current financial year, because for many of us, we'll be looking at Section 100A in a very new light. We're looking at it with a whole lot more ATO guidance in place than maybe what we have in the past, particularly now that we have a final version of that guidance. Couple of other things just to be aware of as we're kind of thinking about that Section 100A final guidance. Some of you might be aware that in the draft version of the PCG, we had 3 kind of coloured risk levels. We had a white zone, which was basically for very old arrangements, but we then had 3 levels of risk effectively, kind of low, medium and high. Well, the ATO has done away with that medium category and basically is just focusing on the low and the high, but then indicating that if you don't fall within either of those 2 broad categories, what is it that the ATO will use from a practical point of view in determining the level of risk? And so there's some indication from the ATO, things like the level of complexity involved in the arrangement, the level of contrivance, how much of a tax benefit relates or results from the arrangement. They're the sorts of things the ATO will look at where you don't fall within the high risk or the low risk categories. For those of you who have looked at the low risk category that deals with the retention of funds in the trust, you'll notice in the final version of the PCG that the ATO has kind of split out that category into 2 kind of subcategories, one for individual beneficiaries and one for company and trust beneficiaries. It's worth having a look at that closely because the ATO has kind of tinkered a little bit with the guidance in that area. It will look broadly the same as what you had seen before. But again, it is worth just kind of getting your head around exactly what it is the ATO is looking for, if indeed you want to fall within that low risk category. So yeah, there's a bit that's going on. It's good to have a final version of this guidance. We may, though, see some further updates to this as time goes on, but we'll obviously let you know if and when we see further changes.
Have the courts had anything to say about this area recently?
Yeah, this is an area that not only have we seen some beefed up ATO guidance in this area, but we've also seen some decisions from the courts starting to filter through in this space as well, which is interesting that these two things are kind of converging at the same time when we really haven't heard much about Section 100A for a number of years, really in any sort of depth. Now, two cases that have been kind of floating through the courts over the last little while where appeals are in place, and so it's a little bit hard to say with any kind of certainty where we're going to end up because we just got to wait and see where these things go. But there has been a recent decision in the Guardian case, and that's one of the two cases that has looked at Section 100A. Now, I think a lot of people were hoping that we would get some clarity on certain aspects of Section 100A through that most recent decision in the Guardian case. But we probably didn't get what we were expecting to or hoping for. Look, I think a lot of people were hoping that the courts would really dig into this idea of what is an ordinary family or commercial dealing. And this latest decision in the Guardian case really didn't get there. It didn't need to get there because the court was focusing more on the concept of what is a reimbursement agreement, because that is one of the big preconditions for Section 100A to be triggered. If there is no reimbursement agreement, as per what the legislation says, then Section 100A shouldn't apply, and therefore you don't have to worry about exceptions to the rules that might come later down the track. In this particular case, it seems like the court was basically happy to say that it didn't look like there was a reimbursement agreement in this case, so Section 100A wasn't probably the key issue. But the thing we need to remember here is that just because Section 100A doesn't apply, doesn't mean other integrity rules couldn't apply. And interestingly, the court here is suggesting that there could be a Part 4A problem with this case. So something for us to remember, not just in the context of Section 100A, but elsewhere in the tax system is just because you aren't caught by a specific integrity rule within the tax system, doesn't mean that's your job done and you don't have to look any further than that. For example, in the income tax system, Part 4A, the general anti-avoidance provisions, that needs to be considered. Even if you don't trigger a specific integrity rule, you do need to still then go that extra step and consider more general integrity or anti-avoidance rules. And the Guardian case is a great example of that. We've got a specific integrity rule, but over and above that, we also have some general anti-avoidance rules that could apply regardless of whether that specific integrity rule applies. So a really good reminder coming out of that case. Look, we don't know if this is the final decision. We're going to wait and see how the appeals process goes. So we don't necessarily want to get stuck into the detail too much at this point. But it is worth just pointing out that there are some cases at the moment that are running, looking at Section 100A. And that might mean that the ATO, having finalised this ruling and this PCG, maybe at some point in the near future need to start making some initial changes based on whatever the courts are saying in this area.
Inflation is never too far from the conversation right now, and with the December CPI figures that were released, that has an impact on superannuation and retirement thresholds. Jason, what can you tell us about that?
We have been eagerly awaiting those figures this year because those figures are what will determine the transfer balance cap for our retiree clients. So the transfer balance cap has been around since 2017, July 2017. That started off at a 1.6 million figure. It was indexed in 2021 to 1.7. And now that we have the CPI numbers for December 2022, we're looking at a double lot of indexation for this financial year or the coming financial year. So we're looking at that general transfer balance cap going from 1.7 million to 1.9 million. So that will present some great opportunities for our clients that are coming up to retirement. Care does need to be taken with existing clients that have account-based or retirement pensions. So the indexation is a little bit tricky for those that are already in the retirement system. So anyone that has used their full cap in the past, so whether that be the 1.6 or the 1.7, those people that have used their transfer balance cap in the past, they won't get indexation. So they'll be stuck with their 1.6 or 1.7. People who have used part of the cap in the past may get some partial indexation, and then the new clients coming into the retirement system after the 1st of July 2023 will have that $1.9 million cap. So sounds quite confusing, but the good thing is that the ATO portal does list each individual's personal transfer balance cap. So it's important to have a look there before we're looking at commuting or starting new retirement pensions. So the ATO portal is that real source of truth. But certainly for new people to the system, we'll be working with that 1.9 million from 1st of July 2023.
So is the transfer cap change law, or does something need to be introduced?
The indexation of the transfer balance cap is actually already written into law. So once it reaches a certain figure at each December's CPI figures, then it will be looked at, and when that figure gets high enough to go up by at least $100,000, that's when the indexation occurs. We don't need any law changes for this to be in place from the 1st of July 2023. However, I will caveat that a little bit with the fact that we do have a budget coming up in May. So the Labor government are yet to really put their stamp on the superannuation system. So there has been some talk around perhaps them looking at some limits. But at this point, if nothing changes in the budget, then this is automatically law from the 1st of July 2023.
What about the annual superannuation contributions cap?
As with everything superannuation and retirement, there's always complexity. So the superannuation caps themselves, so that would be our annual concessional and non-concessional caps, they're actually indexed to a WATI. So rather than CPI, they're indexed to wages. That number won't be out until the coming months. So we'll keep you updated on those caps and whether they are to change on the 1st of July 2023. What is linked? So there is a link between the general transfer balance cap and contributions, in that the general transfer balance cap of 1.9 million is the level where someone under that can make non-concessional contributions. So we at least know that much, that someone with super below 1.9 million will be able to make at least 1 year of non-concessional contributions, but we'll know in the next month or so whether the caps themselves will increase.
Are there any strategic opportunities for retirees and pre-retiree clients?
Yes, so thinking about strategic opportunities, there can be some from a pension point of view and also a contributions point of view. So those, we spoke about indexation, which can be a little bit complicated, but people that are retiring in the coming months, they may want to consider perhaps starting a pension in July rather than say May or June, and that way they would get access to the full 1.9 million transfer balance cap. So there could be some deferral opportunities there for soon-to-be retired clients. Also, from the contributions point of view, we're in a current situation where people with over 1.7 cannot make any NCCs. So looking forward to next year, that will actually be 1.9. So that could open up at least some ability to make an annual non-concessional contribution for some clients. And once we have those caps as well, those concessional and non-concessional caps, we'll be able to speak more specifically on that, but it will certainly open up some opportunities in the non-concessional contribution space. So concessional contributions aren't constrained by total super balance, but non-concessionals are. So some opportunities there, potentially around extra contributions or even re-contribution strategies, which can be helpful for estate planning purposes or even making contributions for a spouse as well. So there'll be a bit to unpack going into next financial year once we have those annual caps, and also once we have gotten through our May budget as well, to see if anything else does indeed change.
Now across to the contractor versus employee distinction. There have been some significant decisions that have been handed down by the High Court. What can you tell us about the ATO's response to those High Court decisions?
Yeah, the ATO has definitely responded, and part of the response is updating some existing guidance in this area. So the employee-contractor distinction, really crucial area for many businesses and also workers as well, because that distinction can lead to some very different outcomes under the tax system, under the superannuation system, and other areas as well, both from a federal point of view in terms of the tax system, but also state-based obligations too. Now, the High Court back in 2022, early 2022, handed down a couple of decisions at the same time dealing with this area, which has really shifted the way that we need to look at the employee-contractor distinction and how we go about determining whether someone is an employee under common law, so under general principles. And basically what the High Court said was that as we're working through that analysis, we need to be looking at the arrangement through the lens of the contract that's been entered into between the two parties. So if the business and the worker have committed the terms of that relationship to a written contract, that's where we should be really focusing our attention. So rather than looking at the conduct of the parties and how their working relationship actually plays out in practice, we should be coming back and looking at what's in that contract. Now that assumes that that contract is not a sham and it hasn't been challenged, but if we do have that written contract in place, that is the thing that is going to guide us as we figure out whether this worker is an employee or not under general principles. Well, the ATO, after the High Court released its decisions, the ATO did release a decision impact statement indicating that, yes, this is a new way that we should be looking at this area, and indicating that the ATO would be reviewing its existing guidance in this area. Well, the ATO has now started to release some of that updated guidance. And the first thing the ATO has done is release a draft tax ruling, which replaces an older ruling that dealt with this distinction in the context of the PAYG withholding system. So the ATO does say, look, this ruling is very much aimed at the PAYG withholding system, but I think we can take from it that if we're going to be working through that distinction, certainly from an ATO point of view, that a lot of those factors are going to be relevant in other areas as well. Now, where things get a bit different though is because other areas have different definitions of employee, and the superannuation guarantee system is a prime example of that. The SG system, it has an expanded definition of employee. So just because a worker is not an employee under general principles, they can still be deemed to be an employee if they fall within certain other categories. This draft ruling doesn't go into that area. We have an older super guarantee ruling that continues to be the place we go to when we're looking at that expanded definition of employee. Having said that, the ATO has indicated that it will be reviewing that older ruling as well in light of what's gone on more recently to see whether the position does need updating as well.
Has the ATO released anything that might help us work through this step by step in practice with our clients?
Yeah, the ATO hasn't necessarily given us something that we can just kind of plug in details and it'll tell us the answer at this stage anyway. But there is certainly something the ATO has released which will help us determine where we sit from a risk point of view. And certainly when it comes to the business that's hiring the worker, we now have a bit of a framework in terms of what we need to do in order to be at a pretty low level of risk in terms of the ATO applying resources and kind of compliance activities to the arrangement. So in addition to the draft ruling that's been released around the employee contractor distinction for PAYG withholding, the ATO also released a draft PCG, so practical compliance guideline, which looks at this employee contractor distinction and how the ATO plans to devote compliance resources, setting out a bit of a framework when it comes to risk and differentiating between different types of arrangements. Now, the ATO has, I guess in that PCG, kind of started off with a bit of a very high level summary of what does it mean if someone is an employee or contractor. So again, for those who are relatively new to this area, it's not a bad way to start, just to find out, well, if someone is an employee, what does that mean for the business and the employee? And likewise, if they're a contractor, what does that actually mean practically? The next part of the PCG then sets out this risk framework. Four different levels of risk, which kind of explain to us what the ATO plans to do in terms of compliance resources. So for example, the ATO has indicated what you would need to do to ensure that you are at a very low level, I guess, risk of the ATO seeking to review the situation and kind of disturb the position that you've reached. For example, to fall within that category, there are a number of things you need to show. One of those is that there is evidence that the business and the worker have agreed on the way that the worker will be classified. Not only that both parties acknowledge what the obligations will be as a result of that classification. So it's clear evidence that the two parties have agreed on the classification. Ideally, that will be in writing. And not only that they agree on the classification, but they both understand what that means in terms of obligations that are going to apply to each party. Well, beyond that, you need to show that the arrangement hasn't significantly changed. You need to show that the business is actually complying with those obligations that it has kind of said already that it's subject to. But there is one other really key element to this, in order to fall within that very low risk category, you need to show that you've sought advice. So as a business, you need to be able to show that you have sought formal advice either from in-house counsel, if that's relevant, or from an external party who is appropriately qualified to give advice in that area. And of course, that advice needs to agree with the classification that you've reached. Now, if all of those conditions are met, the ATO says they generally will treat that as a very low risk arrangement and wouldn't normally seek to disturb the classification that's been reached, presumably unless there is evidence of a significant shift in the nature of the relationship, the working relationship. So that is just one of the categories. You kind of then go up a little bit depending on whether some of those conditions aren't satisfied. And obviously the risk level increases a little bit depending on whether you have or haven't done all of those things. So this doesn't necessarily tell you how to figure out whether someone's an employee or a contractor. There are a number of things you need to look at to do that, and the draft ruling will help you with the factors that need to be considered. But this will certainly help in terms of, well, what do you need to tick off if you want to be at very low level of risk of ATO review or challenge? The thing that used to help us in terms of actually reaching a decision was the ATO's online tool, Employee Contractor Online Tool. Now, that may well become available again to us at some point, but right now it's not. At the moment, it's kind of been taken offline, and the ATO said that they're reviewing it and presumably looking at whether it can be re-released in a modified form to take into account those High Court decisions that I referred to earlier. So for the time being, the tool that we maybe have been able to use to try and help us figure out whether someone's an employer or a contractor, it's not available right now, but the hope is that a modified, improved version of that tool will become available at some point. And in the meantime, that draft PCG will help us to understand, well, what is it that we need to do to manage the risk level that's associated with this, certainly at least from an ATO point of view.
Tax compliance in the sharing economy is one of those big ticket items. And with legislation that was passed late last year, we can expect a crackdown coming very soon from that legislation. Matthew, what can you tell us about the legislation and its likely impact?
We've had some warnings that this was coming for some time now. The sharing economy or gig economy, whether that be renting accommodation, sharing assets, or ride sourcing, has been a bit of an ATO focus area for some time now. They've been quite active in reminding us that income derived from these activities is typically going to be accessible. It's just that now electronic platforms like Uber and Airbnb are now being brought into the taxable payments reporting system. What that effectively means is that these platforms will be required to provide certain details like who's receiving payments to the ATO. That shouldn't come as a surprise to many of you. They've been talking about this for some time now. There was a previous attempt to bring in legislation, but that legislation lapsed. Now it's just been effectively reintroduced. And that legislation has passed Parliament, it's received royal assent, and is now law. So in terms of timing, electronic platforms that facilitate taxi travel and other short-term accommodation, they've got effectively 5 months. So this will come into effect for them from 1 July 2023. For other platforms that allow users to share other assets or provide other services, they've got an additional year. So this will come into effect for them from 1 July 2024.
What should we be telling clients about this area?
Well, the taxable payment reporting obligations are imposed on the electronic platforms. So it's not the users that need to provide additional reporting to the ATO. Having said that, I think the message is quite clear. The government has some concerns that payments in this area are not being appropriately disclosed as accessible income. These measures will in turn help the ATO to ensure that they've got the data to go out there and make sure people are complying. So if you're sitting down with clients that are involved in, thinking about getting involved in, or might be involved in the sharing economy, it's just worth letting them know about this reporting regime. And there are real risks around non-disclosure.
And that's the roundup for this month. If your firm is not a member of Knowledge Shop already, whether you're an accountant or whether you're a financial advisor, the team would love to show you the help desk, the work papers, the client newsletters, the training that we can offer to help make the lives of practice just that little bit easier every single day. We look forward to speaking to you soon.